Thank you, Mr. Chairman. I will try to keep it fairly brief. In the bill on line 87, through you, Mr. Chairman, if I would ask the proponent of the bill, it had previously indicated that the release of the information was permitted if required by federal law. Through you, Mr. Chairman, is that including if there is a law that specifically requires the disclosure?
Representative Lamar.
Yes, if there's a law that specifically requires the disclosure, then I think that would be under there. But there currently is no law that requires that specific disclosure.
Representative Dubitsky.
Thank you, Mr. Chairman. I would ask the proponent of the bill if he's seen 8 U.S.C. 1644. Notwithstanding any other provision of federal, state, or local law, no state or local government entity may be prohibited or in any way restricted from sending to or receiving from the Immigration and Naturalization Service information regarding the immigration status, lawful or unlawful, of an alien in the United States. That's one of the several federal laws that seems to require the release of the very information that is prohibited in this bill. And it seems like under the bill it would be required to be disclosed. So it almost seems like there is an exception in this bill that swallows the law. Through you, Mr. Chairman.
Representative Lamar.
Thank you, Mr. Chairman. Don't know that I am equipped to get into a legal debate with a member of the Connecticut Bar. But my understanding of this, one, is that the Second Circuit has held that states can limit communications and information under a general confidentiality policy, including immigration status, and that we are in accordance with the federal courts who in 2014 held that it's unconstitutional to require local law enforcement to hold individuals based solely on these immigration detainers because it constitutes a warrantless arrest and violates the Fourth Amendment. And we are by passing this, we would be modeling local and state ordinances and laws across the country. And I think it's clear with that preponderance of evidence that we are not in violation of any law that would run us afoul of line 87 in the attached legislation.
Representative Dubitsky.
Okay, well, I wasn't talking about the detainer part. Others have discussed the detainer. I'm speaking specifically about the release of information, and there seems to be a specific federal statute that requires the disclosure when requested, and in the bill itself there is a specific provision that the information shall be released if required by law. So at least to me it appears that with regard to the release of information part of the law, that it is already specifically not only preempted by federal law, but by its own terms. So I won't get into a legal debate with you, but it doesn't seem like, based on that section of the statute actually does anything, because it would require the disclosure of that very information under line 87. So I'm really not sure what it does. The other thing I would ask the proponent is, with regard to lines 84 through 86, also with regard to the release of information. Earlier it was discussed about that it was not ICE's function to investigate certain state crimes and therefore it would not be appropriate to release that information to them. While we were sitting here, I looked at ICE's website and their most wanted, and some of their most wanted are wanted on human trafficking, illegal gambling, conspiracy to export cocaine, criminal assault, criminal sexual assault on a minor, lewd and lascivious acts, smuggling into the United States. Those are all pretty serious crimes that are specifically under the jurisdiction of the Immigration and Customs Enforcement Department. And it would appear to me that this section 84 through 86 is limited only to terrorism, but it does not encompass those other serious crimes that are not on the immigration side of ICE's charge, but on the customs enforcement and human trafficking side. And I was wondering if you might be able to address why it would be limited to potential terrorism and not also include all those other horrific crimes that are clearly within ICE's charge. Through you, Mr. Chairman.
Representative Lamar.
Thank you. Again, we will not, the purpose of having this policy is to ensure that we do not hold individuals on immigration-related and federal crime-related circumstances for violating immigration law. Our local and state authorities will not be holding folks on detainers based upon a voluntary request. In circumstances where there are people who've been fingerprinted because they're under our custody, and those people have been noticed to ICE, and they have them under watch for other crimes, and they've got a depository of those crimes, they can receive a judicial warrant and hold those individuals for those crimes. But we will not be holding individuals on a voluntary detainer. But ICE itself can secure a judicial warrant and rearrest those people and prosecute them under whatever charges that they are willing to bring.
Representative Dubitsky.
Okay, but the part of the information that becomes a violation is that a state law enforcement would be subject to suit if they released a detainee's income tax or other financial records, including Social Security number. And it would appear to me that during an investigation into illegal gambling or conspiracy or smuggling, that ICE would need that information, and regardless of whether regardless of whether the state was going to hold this person, if there is an investigation, a criminal investigation into a significant crime, federal crime, it would appear to me that it would be advisable that we would be able to provide to ICE that financial information so they can investigate the serious crime, regardless of whether we're going to just hold this person subject to a civil hold. If ICE believes that there is investigating this person who is in our custody for a significant federal crime, in many of these cases I imagine they're even international crimes, it doesn't appear to me that it would be wise to withhold simple things like financial information and a Social Security number. Through you, Mr. Chairman.
Representative Lamar.
Thank you, Mr. Chairman. Yes, one, I believe that ICE could compel that information by securing a warrant. Two, I think that gets back to your first question, where the condition where the release of such information is otherwise required by law. Once that person has been rearrested by ICE and is going through the criminal procedures and processes, then certain requirements of the state of Connecticut are in fact obligatory upon us, and we would release the information in those circumstances for the prosecution of that crime. All we are asking to do, again, no law enforcement shall communicate with any officer, employee, or other person paid by or acting on behalf of the United States Immigration and Customs Enforcement regarding the custody status or release of an individual who is subject to a civil immigration detainer. Now, upon release, once they are no longer in our custody, we have determined we are not going to hold them on a voluntary detainer. We are going to release them once we've determined that they are no longer under investigation or adjudication for state-level crimes. And ICE determines that they are going to rearrest an individual. We are compelled to comply with, when they secure a judicial warrant, they rearrest that person, and every state agency is compelled to comply with whatever legal requests that ICE makes of us, if it's regarding tax information or whatever else it is. That has no bearing on the overall process by which an individual is being held, and ICE seeks a voluntary detainer, and we determine to not honor that voluntary request. And we do not communicate in that period of time with them about the confidential information that we've outlined. But post our release, if ICE secures a judicial warrant and rearrests that individual, they can compel from the state of Connecticut the information they need to carry out their investigation.
Representative Dubitsky.
Oh, okay. Thank you. Through you, Mr. Chairman. So I just want to make sure I understand this. ICE calls up the state police and says, we are investigating this person for drug smuggling, human trafficking, criminal sexual assault on a minor, smuggling into the United States, and illegal gambling. We don't yet have enough information, enough evidence to arrest. We are investigating, but we know you have this person. Can you give us his Social Security number, and and the state police would be required to say no, and then they say, okay, well, we would like to arrest him. We think we may be able to get enough information, enough evidence to arrest him. When is he being released? And the answer would be, we're not going to tell you. Through you, Mr. Chairman.
Representative Lamar.
Thank you. So the communication is typically just a letter, essentially asking them to hold that individual, and it's usually for unspecified reasons. In the circumstance that you've outlined, I presume that should be enough information for ICE to secure a judicial warrant and rearrest that individual, I would presume. What federal courts have determined is it is illegal for us, it's unconstitutional for us to require our local law enforcement to hold on to that individual due to an ICE detainer request. If an individual is under investigation and they've got this level of information that they've acquired and secured, it shouldn't be that much more difficult to take the next step to secure a judicial warrant and rearrest that person. We will not be communicating with them the confidential information while they are under our hold, though.
Representative Dubitsky.
Okay, I thank the proponent for that information. It appears to me like what we're doing is we are almost deliberately preventing the federal government from investigating and arresting criminals who are who under extreme situations, who are accused of horrific crimes, all within the charge of a federal law enforcement agency in direct violation of a specific federal statute. I certainly could not support that. Thank you, Mr. Chairman.
Thank you, sir.